So for today, I'm going to make a lecture video. It's been a while since my last lecture video because in the past few weeks, I've been making video case digests of the Justice Leonen civil law decisions. So pahinga muna tayo doon. But today, I will make a lecture on civil code, general principles, and human relations. So if you are a first-year student taking up persons and family relations, or a fourth-year student taking up civil law review 1, or a bar reviewee preparing for the bar, then this video is for you. So sit back, relax, listen, and learn. So let's begin. Welcome back. So let's begin. This is general principles, effectivity and application of laws, judicial decisions, and conflict of laws. Now, this lecture will follow the order of provisions in the civil code. So, to be exact, we will only be talking of Articles 1 to 36 of the civil code. So let's start. What is Article 1? Article 1 provides that this act shall be known as the Civil Code of the Philippines. The Civil Code of the Philippines took effect on August 30, 1950. So, August 30 lang So, ilang taon na ang Civil Code? 71. So, yan. 71 years old na po ang Civil Code. After celebrating its 71 years last August 30. Now, the Civil Code of the Philippines is Republic Act 386. So it was a law passed by Congress, signed by the President, but the draft of the Civil Code was, of course, prepared by legal luminaries such as, including Senator Arturo Tolentino and Justice Francisco Capistrana and others. Okay, so you can really see, the legal knowledge, the depth of legal knowledge, put in this Civil Code of the Philippines. All right, so speaking of effectivity, Article 2 provides that laws shall take effect after 15 days following the completion of their publication in the Official Gazette, unless it is otherwise provided. This code shall take effect 1 year after such publication. Napansin nyo ba, Article 2 only provides publication in the Official Gazette. Okay, so meron bang may kopya ng Official Gazette sa inyo? Have you ever seen Official Gazette being sold anywhere? Okay, so that posed a problem. So that's why EO number 200 dated June 18, 1987 was signed by President Corazon Aquino, and in that it was provided that law shall take effect after 15 days following the completion of their publication either in the Official Gazette or in a newspaper of general circulation in the Philippines unless it is otherwise provided. So now laws can be published in either the Official Gazette or in a newspaper of general circulation because we have to admit, Official Gazette is rarely published, and if it is published, the readership is very low. Unlike newspapers, more or less you can expect that these newspapers will reach even the most remote places of the country and will reach people or Filipinos of all ages and of all walks of life. So kaya a law cannot be published in either. Okay. Now, when a statute does not explicitly provide for its effectivity, it shall have effect only after the expiration of the 15-day period following the completion of its publication, either, again, in the Official Gazette or in a newspaper of general circulation in the Philippines. So take note also that publication must be in full or it is not publication at all, since its purpose is to inform the public of its contents. That's why it's not enough that only the title or even the summary of the law should be published. It should be the entire text so that we know what the law is about, and with that, we are able to comprehend and, of course, follow the law. Now, the clause, unless it is otherwise provided, solely refers to the 15-day period and not to the requirement of publication. Publication is an indispensable requisite, the absence of which will not render the law effective. If the law provides for a different period, shorter or longer than the 15-day period provided by Section 1 of EO number 200, then such shorter or longer period as the case may be will prevail. If the law provides that it shall take effect immediately, it means that it shall take effect immediately after publication, pwedeng kinabukasan after the last day of publication. The effectivity provision here refers to all statutes, including those local and private laws. All right, now Article 3 provides that ignorance of the law excuses no one from compliance therewith. Okay, sounds familiar? Yes, it should be because it is our duty to know the law. Okay, so when a law is passed by Congress, duly approved by the President of the Philippines, properly published, and consequently becomes effective pursuant to its effectivity clause or to some provision of a general law on the effectivity of statutes, the public is always put on constructive notice of the law's existence and effectivity. And this is why Article 3 and Article 2 go together. There is a need to publish these laws because ignorance of the law excuses no one. Alright, now Article 4 states that law shall have no retroactive effect unless the contrary is proved. So the law looks to the future and has no retroactive effect unless the legislature may have given that effect to some legal provisions. Ibig sabihin, dapat forward-looking ang batas, hindi na lumilingon, hindi na tumitingin sa likod, kumbaga, sa nakaraan. Alright. However, in the following instances, a law may be given retroactive effect. So number one, when the law expressly provides for retroactivity. Okay? It must be expressly stated there because it cannot be assumed. Second, when the law is curative or remedial, ibig sabihin it seeks to heal or cure let's say an injustice or a wrong committed in the past. Third is when the law is procedural because procedural laws apply even to existing actions or existing proceedings. And lastly, when the law is penal in character and it is favorable to the accused. Alright. Next, Article 5. Article 5 states that acts executed against the provisions of mandatory or prohibitory laws shall be void except when the law itself authorizes their validity. Now, what is a mandatory provision of law? A mandatory provision of law is when the omission of which renders the proceeding or acts to which it relates generally illegal or void. Ibig sabihin, if it's mandatory, dapat sundin. If it's not followed, then the act is illegal or void. Now, prohibitory laws, on the other hand, are those which contain positive prohibitions and are couched in a negative or in the negative terms importing that the act required shall not be done otherwise than designated. Kaya nga prohibition, no? It forbids something to be done. So yan po ang prohibitory laws. So kung ang mandatory law is something that requires you to do something, prohibitory law is a law that forbids you, okay, from doing something. Alright, next is Article 6, and Article 6 provides that rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Now, waiver is the intentional relinquishment of a known right. Waivers cannot be made if they are contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Now, in your political law, you will remember that for a waiver to be valid, there are requisites. So, number one, the person making the waiver or executing the waiver must be aware of the existence of the right. Okay? And second, he must voluntarily renounce the right. Alright. Okay, next. Article 7 states that laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. When the courts declared a law to be inconsistent with the Constitution, the former, meaning to say the law, shall be void, and the latter, meaning the Constitution, shall govern. Administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the laws or the Constitution. So, repeal of a law is the legislative act of abrogating through a subsequent law the effects of a previous statute or portions thereof. Repeal is either express or implied. An implied repeal takes place when a new law contains provisions contrary to or inconsistent with those of a former without expressly repealing them. Okay, what is of course preferred is an express repeal. And malalaman mo naman kung express repeal because in that law, sasabihin naman that the provisions of Republic Act 1234 are hereby deemed repealed. Something like that. And the same goes for even rules, no? Like the rules of court, for example. Recently, like 2019, the Supreme Court passed the rules on civil procedure, the amended rules on civil procedure. And in these rules, certain provisions, like for example, the provision or the rule on motions to dismiss, ni-repeal talaga siya ng 2019 amendments. Alright, so those are examples of express repeals and implied repeals. But only a law can repeal another law. Okay, so even the Supreme Court cannot repeal a law. What the Supreme Court can do, of course, is to declare a law unconstitutional. So parehas lang naman ang effect nun whether a law is repealed or a law is declared unconstitutional, parehas lang. But then when we say repeal, that is a legislative act. And the reason for the repeal is either it is contrary to the Constitution or it is contrary to maybe a public policy. So there are many causes for repeal, and it's of course addressed to the sound discretion of Congress. All right, now more on repeal, of course, in your subject called statutory construction. So marami kayo matututunan doon. Now, the Constitution is the supreme, organic, and fundamental law of the land. It is axiomatic that no ordinary statute can override a constitutional provision. Kaya nga, is the supreme law of the land. Wala na mas mataas pa sa Constitution. Alright, Article 8. Article 8 of the Civil Code provides that judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. So, in effect, judicial decisions, although in themselves are not laws, they assume the same authority as the statute itself, and until authoritatively abandoned, necessarily become, to the extent that they are applicable, the criteria which must control the actuations not only of those called upon abide thereby, but also those duty-bound to enforce obedience thereto. That's quite a mouthful. Ibig sabihin lang, a judicial decision, if they interpret the law, they are part of the law because they give guidance to those who are mandated to abide by the law or to enforce the law. Now, lehis interpretation or interpretasyon, lehis vim obtinet. The interpretation placed upon the written law by competent court has the force of law. Alright, now Article 9 is quite interesting because it says, no judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. Now, judges must not evade performance of this responsibility just because of an apparent non-existence of any law governing a particular legal dispute or because the law involved is vague or inadequate. The judge must always be guided by equity, fairness, and a sense of justice in these situations. Indeed, when the law is silent or there is a gap in the law, the judge should use equity to fill that gap, okay, in order to render justice in the situation. Alright, now Article 10. Article 10 provides that in case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Okay, there's that the presumption of regularity, that the law is always meant to do what is right and what is just. So if there is an ambiguity in the law, interpretation of the law requires fidelity to the legislative purpose. What Congress intended is not to be frustrated. Its objective must be carried out. We are not here to question the wisdom of the Congress. No, we have to obey and we have to carry into effect the wisdom and the purpose of the legislature in enacting the law. So even if there is a doubt as to the meaning of the language employed, the interpretation should not be at war with the end sought to be attained. Alright, Article 11 provides that customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12, meanwhile, provides that a custom must be proved as a fact according to the rules of evidence. Now, a custom has been defined as a rule of conduct formed by, note, repetition of acts, uniformly observed as a social rule, and legally binding and obligatory. So, pag tinanong kayo what is a custom, yan na po ang definition. So take note of the elements there. Okay? Repetitive, uniformly observed, also legally binding and obligatory. Okay, Article 13. Article 13 provides that when the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. Now, take note that in computing a period, the first day shall be excluded and the last day included. Now, this finds great importance and application in computation of reglementary periods and prescriptive periods, no? Especially in actions, both civil and criminal cases. So take note of the rule, particularly the second paragraph, which states that in computing a period, the first day shall be excluded and the last day included. Gusto nyo an example? For example, today is what? September 2. Okay, September 2, 2021. Okay, so let's say you received an order from the court to file a comment to a motion within 15 days from receipt of the order. Okay, so you count the 15-day period by excluding the first day, meaning to say today, and adding the last day. All right, so you add 15 days from September 2. Okay, so 2 plus 15. Okay, so that's 17. All right, so 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. All right, so that's how you compute it. All right, now Article 14 provides that penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. Okay, so if you have taken criminal law, okay, this is part of Book 1, and the topic is, of course, the territoriality principle, that our penal laws are only effective within the territory of the Philippines. Okay, and anyone who sojourns or travels to the Philippines shall be subject to our penal laws and to our criminal law, criminal legal system. All right. Okay, now Article 15 provides that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines even though living abroad. So regardless of where a citizen of the Philippines may be, he or she will be governed by Philippine laws with respect to his or her family rights and duties or to his or her status, condition, and legal capacity. So ano ba itong mga attributes or characteristics na to, no, na sinasabi na once you're a Filipino, you are subject to the laws of the Philippines. So, of course, these are your personal rights and obligations, your personal capacity. Okay, so even if, let's say, in other countries, the age of capacity there is, let's say, 16, but since in our country, our age of capacity is 18, so we are so a Filipino can only acquire legal capacity to enter into contract even if living abroad if he reaches the age of 18. So another example, maybe let's say in another country, let's say a person can marry at age of, let's say, 14, okay, but since Philippine law states that the age of capacity to marry is 18, so ganun din, no? So hindi ka pwede magpakasal sa ibang bansa if you are just 16, even if in that country the age of marrying or the marrying age is 14. Alright, because of the national principle. Now, also, duties, no? For example, the duty of support. So that is governed by the national law of the person. So if you're a Filipino, let's say you travel abroad, you stayed and lived in a country where there is no obligation to give support to your children, okay? You cannot avail of that exemption even if you are in that country, because what applies to you as far as, you know, the duty or obligation to support is Philippine law. And under our Philippine law, okay, a parent has the duty and an obligation, a legal and moral obligation, in fact, okay, to give support to his minor and dependent children. Alright, so let's now talk about Article 16, and Article 16 provides that real property as well as personal property is subject to the law of the country where it is stipulated. No, it's where it is situated. Okay. Pasensya na, tao lang. Alright, so, however, in the state and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. So Article 16 gives us the first paragraph gives us the rule on lex re site. In other words, the law of the place where the property is located. But the second paragraph is a nationality principle. Okay, and this is with respect to succession, especially the intrinsic validity of succession. So what is intrinsic validity? Intrinsic validity refers to rights of the person succeeding to the decedent, or the right or the prerogative of a decedent, okay, to dispose his property. So those are intrinsic validity because they refer to rights. No? But as far as the property is concerned, okay, even if they are subject to a will, okay, and the intrinsic validity of the will is expectedly or naturally governed by the national law of the decedent. But if kung merong property na involved doon, the disposition of that property, including transfer, title, and disposition of that property shall be governed by the law of the place where that property is located. All right. Now, the third, as a commentary, of course, the law of the country where the real property is situated shall be the governing law over such real property. However, with respect to the order of succession and the amount of successional rights, whether in intestate or testamentary succession, they shall be regulated by the national law of the deceased, and this is applicable regardless of the nature of the property. O, inulit ko lang yung sinabi ko kanina. Article 17 provides that the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Now, the third paragraph provides that prohibitive laws concerning persons, their acts of property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in a foreign country. Importante yung dalawa dito, no? Because these two paragraphs under Article 17 actually give us the rule of lex loci celebrationis, or in some jurisdictions they call it lex loci contractus. Okay, so this means that the formalities of a contract, an instrument, including wills, no, shall be governed by the law of the place where it was celebrated, where it was executed, where it was signed. But this is only with respect to formalities. Ano nga ba yung mga formalities? Formalities are those requirements that are related to the execution, yung paggawa nung papel. So for example, if let's say in this country, of course, the sale of a movable or of an immovable property or a real property must be in a public instrument as provided under Article 1358 of the Civil Code. Now, let's say that deed of sale is executed in another country, let's say country X, where it is not required to be in a public instrument, meaning hindi kailangan inotaryo. Okay? Now, yung requirement na pagnonotaryo, that's a formal requirement, and according to Article 17, the formalities of instruments shall be governed by the law of the place where it was executed. So kung dun sa bansa na yun kung saan pinirmahan yung deed of sale, hindi kailangang ipanotaryo yun, then that is valid here because it was valid where it was executed. Alright, now however, take note of the second paragraph because the second paragraph states that if the document or the instrument is executed or signed or presented before the diplomatic or consular officials of the Philippines, it is as if those documents were executed in the Philippines. Because itong mga embassies na to, itong mga consular offices na to, they are extensions of Philippine territory or Philippine jurisdiction. Kaya masusunod doon yung requirement na batas ng Pilipinas. Kaya yung sinabi ko na Article 1358 of the Civil Code, which applies to the execution of deeds of sale over real property, applicable din yun dun sa papel, dun sa kontrata na pinirmahan at pinanotaryo sa embassy or embahada ng Pilipinas. Alright, yung last paragraph, this is just a reiteration of the previous provision which states that acts in violation or in contravention of mandatory and prohibitive laws shall be void. No? Now, ang sinasabi lang dito is that if it is void in the country, in this country, the Philippines, because of some prohibitory law, hindi siya naging valid if it was executed in a country where it was allowed. Halimbawa, bigamy, of course, is illegal in the Philippines. So, yung batas na yun, applicable pa rin yun, no? Hindi nababaliwala yun just because the marriage, for example, was celebrated abroad. So, kung halimbawa doon sa ibang bansa, allowed ang bigamy or polygamy, hindi ibig sabihin allowed dito sa Philippines kasi hindi po applicable yung Lex Laws and Celebration sa ganung sitwasyon because we have a prohibitive law on the matter of bigamy. Okay? Alright, so I hope that's clear. Now, the forms, as I've said, the forms and solemnities of public instruments, wills, and contracts shall be governed by the laws of the country where they're executed. Diplomatic and consular officials are representatives of the state, hence any acts or contract made in a foreign country before diplomatic and consular officials must conform to the solemnities under Philippine law. Alright, the next